On the last day of Parliament, Home Minister Amit Shah announced a dramatic development. He said the sedition law of India was being repealed. I'm Barkha Dutt, here with the Mojo story. In moments from now, we'll be talking to Justice Deepak Gupta, former Supreme Court judge, on this big announcement, this big developing story. In fact, the entire Indian Penal Code has been recast, as it were, a new bill that seeks to reimagine the IPC, which is a British colonial era set of laws that govern India, has been placed before Parliament, placed before the country. The headline that is leapt out from this new legislation, new proposed law, is the repeal of sedition. But on closer examination, many questions arise. Has sedition really gone, or is it really old wine in a new bottle, some say, with even more possibly stringent clauses? To talk about all of this, let's introduce our guest on the program today. We're joined by Justice Deepak Gupta. Sir, always a pleasure. Before I place my first question to you and ask you to help us decode these changes, let me just play out for our audience what the Home Minister said on the floor of the House while making this announcement. Listen in.
मान्यवर, राजद्रोह पर कि अंग्रेजों ने अपने शासन को बचाने के लिए एक कानून बना था, मैं इस सदन को कहना चाहता हूं, एक ऐतिहासिक निर्णय इस सरकार ने किया है। राजद्रोह को कंप्लीटली हम रिपील कर रहे हैं, कंप्लीटली। यहां लोकतंत्र, सबको बोलने का अधिकार है। राजद्रोह को हम कंप्लीटली रिपील कर रहे हैं मान्यवर। और इस कानून में इसके साथ साथ अलगाव, सशस्त्र विद्रोह, विध्वंसक गतिविधियां, अलगाववाद, भारत की संप्रभुता, एकता को, अखंडता को चैलेंज करना, ये सबको कानून के अंदर किसी न किसी दाएं बाएं तोड़ मरोड़ कर जोड़ते थे। इसका कोई स्पेशल प्रोविजन नहीं था, टेररिज्म की व्याख्या ही नहीं थी। पहली बार अब इसकी व्याख्या हो रही है और जुड़ी संपत्ति को कुर्क करने का अधिकार भी मिलता है।
So to go against what the law calls, or the bill calls, a sovereignty and unity of India is now a separate offence. It is detailed in section 150 of the bill that has been placed before Parliament. Justice Gupta, it's confusing. We're all still trying to understand the details. On the one hand, the Home Minister said this is a historic decision, sedition. The word sedition no longer will exist on the statutes. On the other hand, we still do have a set of very, very firm laws that look at punishing those who go against the unity and sovereignty of India. I just want your first thoughts.
See, Barkha, to be honest, I have not really examined them in detail. These are just first off the cuff remarks. Maybe I may change my views a little later, but I feel that yes, may not be totally abolished, but there is a change, and a change hopefully for the better. Because earlier, the words were whoever by words either spoken or written. Now the words are whoever knowingly, purposely or knowingly. So two words have been added, purposely and knowingly. So the person must be doing purposely or knowingly. Visually represents, you see, and the other thing is, earlier it was, in what was sedition was, or excites or attempts to excite disaffection towards the government. Yeah. Disaffection is a very, very wide term. What Mahatma Gandhi said, you can't force me to have affection for somebody. So disaffection was a very wide term. Now the words being used are excites or attempts to excite secession. Now secession is a well understood term. It has to be dividing the country, or somebody who moves towards seceding, or armed rebellion.
Yeah.
Or subversive activities. Now, till here, I wouldn't have much difficulty because subversive also can be defined quite well. But the last portion I'm a bit worried about is, or encourages feelings of a separatist activities.
Yes.
Now, this is a bit, I think, unless, I don't know, I've not gone through the act in detail, whether they've defined these words somewhere else. Whether they've defined, what is encourages feelings of separatist activities. But I won't say that it's as broad as sedition. First hand, it looks to be much narrower than sedition.
So let me understand.
The most important is what has been taken away is that criticism of the government can never amount to sedition, can never amount to under sedition or whatever this new offence is, acts endangering the sovereignty,
So,
unity, and integrity of India.
okay, so a lot to ask you. So I'm going to ask you to just lean back just a bit because so we can see you fully. Yeah, there I can see you properly now. Now, my question is this: what you're saying is first impressions are that there is an improvement. It hasn't
Yeah.
completely gone, but there's an improvement. And the
But
biggest change,
definitely a lot of improvement, I'd say.
a lot of improvement. And the biggest changes that you see are one, that criticism of government cannot amount to sedition,
Yeah.
and two, there is an intent or purpose that will now have to be established by prosecuting agencies.
Yes, because words used are purposely or knowingly. So
Yes.
somebody who, I mean, a small young person who just forwards something without, knowing what is the effect of it may not fall under this section. And, the words, because when we talk of interpretation of statutes, there's a principle, a Latin phrase like we always use, justum generis, that the words have to be read together to give a common, string or a common thought to all the words. Now you look at the words used are excites or attempts to excite secession. Now,
Yeah.
secession is clearly understood as taking away a part of this country to somewhere else. Armed, armed rebellion.
Yeah.
Now, that is armed rebellion. Obviously, nobody can support. Subversive activities, again, nobody can support. My only feeling is this encourages feelings of separatist activities.
Yeah.
See, and separatist activities, I can understand what is separatist activity, that could be defined, courts can define it. But how do you just discourage or encourage feelings? There I have a little issue, but I think the rest, or endangers the sovereignty or unity or, and integrity of India, or indulges in or commits such acts shall be punished with. So, it's now a much more confined, it's not, so if you, what was happening earlier was that if you criticize the government,
Yes,
or
sir.
you criticize the powers that be, then it amounted to, there was no dividing line between the country and the government. So that has gone because the words used in the section were government. It is true, I would have been happier if the words armed insurrection or something were used. But even in the absence of that, I think the Supreme Court may go back to the 62 judgment, read it into this also, because the words here, when you read them together, it means and I think armed violence, sometimes in the new age, violence does not necessarily have to be violence of the gun.
So,
We have
in a
to
way,
also, there can be violence through finance. There can be violence, the country can be dismembered through financial activities. So
that
if
is what
somebody
I'm.
attempts that, I'm not
Yeah.
sure whether I am so much of a votary of just armed violence now. I think it's a step in the right direction. Maybe I would have wanted it a little more. Maybe when the definitions come, as I said, we've not read the act totally.
Yeah. Let's talk a little bit about this incitement to violence. The Supreme Court, in an earlier judgment, has said that it is not sedition unless it's seen to incite violence. Now, you're saying how you incite violence is a very broad based set of interpretations. It's not just the physical act of violence. And would you want, therefore, any new law to define this specifically?
I
Because
would.
the law commission, the law commission in its recommendations had actually recommended adding this line about incitement to violence, which so far we do not see in the bill.
No, but the Law Commission wanted to retain sedition. The Law Commission wanted to, if it had been retained in the original form, then again, any disaffection against the government would amount to. I think it's an attempt. I'm not saying it's a perfect attempt, but it is an attempt to improve the situation. I mean, nobody can, neither Barkha, you nor I would support anybody who attempts to, excite secession or armed rebellion or subversive
Yeah,
activities.
of
I mean,
course.
I
Of
think
course.
on these three, there can be no problem. It's only when it comes to encourages feeling of separatist activities. How that is defined, I think either the courts will have to define it or the legislature will have to define it. I have something else. 3 very important bills have come in today.
Yes.
Without any discussion. I mean, when such important bills are being presented to Parliament, I think there should have been some discussion in the legal circles somewhere else. I don't see much. That is where, things can be improved. Even now, it's only a bill. I don't see it as making the offence wider than sedition as it was. Definitely, it makes it narrower. It is a more, it's a definition closer to what I would support, much closer to what I would support.
Well, that is an improvement, but what leaves you concerned is the fact that there's been no debate on such a wide-ranging reform.
Yeah, I really feel that before such, views of people who matter, views of the general public, views of concerned people, I'm not talking only of lawyers and judges, views of people who matter, who really think about the country should be taken into consideration. And I'm not sure, there may be some good parts of these bills, there may be not so good parts of these bills, but we need to discuss them and study them much more before,
Yeah. So broadly, what
I'm not
concerns
sure.
you is... Go
Barkha,
ahead.
I am not sure. I shouldn't be topping. I'm not sure, but I don't think these bills have been put out in the public domain before. Are you aware if they've been put in the public domain before?
As far as I know, I don't think so, but I'd have to check that. That as well.
I don't know whether the Law Commission did it, but then it should have been a much wider discussion. These laws require some changes. I'm not saying that they don't require changes. We have to change with times. But then there should be some discussion. These are very, very important laws which will affect every person. And I think that, but as far as this section goes, definitely for me, section 150 of the new bill is a definite improvement on 124A.
So I think what you're saying is it seems to be moving in the right direction, and one should welcome that. But the fact that there's an entire IPC that's being recast is something that should have been placed in the public domain for public participation in that debate before it was sought to be made into law.
Yeah, I'm not talking about a referendum, but people, it could have been sent to former judges, retired judges. What are their views? Have they sent?
Yes.
Those views could have been asked for. I'm not sure. At least nobody asked for my views. If somebody else's views have been asked for,
all right, sir. I think that you make a valid point, and I think we were all taken by surprise at the fact that the IPC was going to be recast suddenly, and you're saying that could have been a more participatory process with experts, and I think that point is well taken. But on sedition, on this particular section, you think it is a distinct improvement on the law that used to exist.
Definitely, yeah. And this is a welcome surprise, if I may put it. It's
all right. Okay, yeah. And we'll have you back, sir, when you've had a chance to look at the entire new proposed legislation.
Just before I go off, I just want to know, because I've not studied it, I don't know whether it is a cognizable offence, whether the magistrate can take complaint only on the complaint of a police officer. Like previously, Deepak Gupta says Barkha Dutt has committed sedition and some magistrate in Kerala takes up notice. Those safeguards also need to be put in place.
Yeah, I think we definitely all need to examine and read this in more detail, and hopefully there will be a wider debate, at least inside Parliament, before this is made into law. Thank you, Justice Gupta. Thank you.
Thank you so much, Barkha. Pleasure always to be on your show.
Thank you, sir. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.